This is Deb Falsway with End Workplace Abuse, and I want to give you a brief but in depth overview of the new bill language for the Workplace Psychological Safety Act. So, this training will include the why behind the bill and information about the language itself of the Workplace Psychological Safety Act. So, let's start with the why. Our goal is that since no law will fully eradicate a problem and our government is corrupt and inefficient, we want to focus on awareness, prevention, and accountability. So we want to provide relief for people going through this by educating people about it, building a lot of awareness, and also using the Workplace Psychological Safety Act as a tool for employers to prevent the behavior in the first place and provide accountability for those employers who just do not care about employee well being. Sexual harassment law hasn't gotten rid of sexual harassment, but it moved the needle on safer workplaces, even with pushback from the courts over the years. So, our goal is the same. We want to move the needle on safer workplaces. We want to create a norm that psychological abuse at work is unacceptable. And we want targeted employees to know that society is on their side for the harms that they've endured, which we don't have right now. It will not be perfect, but it will be progress. We want to accomplish these goals by calling for consequences that have the best chance of moving the needle on safer workplaces. We want employer accountability. And we really, in drafting this bill, worked to find a spot that we think will be passable, but also has enough teeth to protect workers. So our legislation, besides hoping to have employer accountability ultimately, is also a tool for mobilizing people to take back their personal power and create change. So it's part of the healing process for people. And it's also a way to educate people and make workplace abuse a household term and really get at that educational piece. So, even if we feel like passing a bill is a uphill battle and it feels like there's no hope, which there is, our goal is to really help people understand what's going on and pull back the curtain on how employers are operating so that we can help mobilize people and collectively create change. So let's get into the bill language itself for the Workplace Psychological Safety Act. And I want to first let you know where to find the bill language. So if you go to endworkplaceabuse.com and you go to this first or only drop down under psychological safety, there is a drop down that says the bill. And then when you get to this bill page, you'll see here in the second red circle the link for the bill language, and it will take you directly to the PDF, the most updated, most up to date PDF of the bill language. Right next to it, you will find a link for the findings. And this is a few pages of research, very, very well researched argument for why we need this bill, or why we need this to be a law. So, usually, when I reach out to a legislator, I use the template letter, but if I'm, having a more casual conversation, I will send them the bill language and as well as the findings to create some sort of context for this. Um, so the basic crux of this bill and why we need it is that abuse at work, which has a discriminatory impact, harms people, and anti-discrimination law isn't enough to address it. While those who suffer from similar mistreatment and damage deserve the same protections. We do not have legal protections from abuse at work in the US unless it falls under anti-discrimination law. And anti-discrimination law, like it says, isn't enough. So our solution is to give targeted employees legal recourse for a toxic work environment. If you communicate nothing else to state legislators, that is the overall point. That right now we do not have a way to have a legal claim when we've been abused at work, and this is what this provides. It also really hones in on the employer negligence that happens with this issue. So it requires them to acknowledge, detect, prevent, discourage, and adequately address incidences of psychological abuse. It does not focus on intent or negligence specifically, but rather the toxic work environment using a reasonable person standard. as other existing law does. So anytime you see text with a white background, it is the actual text from the most recent bill language. And I'm going to start with the purpose, which is to ensure the psychological safety of employees and or the work environment without regard to protected class status by holding employers accountable for bullying conduct. And that's really the key here. I just want to pull out a couple of points with this. The first being that it's one thing to have an abusive, um, boss or coworker, although you can under this bill sue an individual. But really, the biggest problem with this issue is that most employers don't address it. So this is about holding the employers accountable. And then when we say without regard to protected class status, we know that the majority of people who experience and suffer from workplace abuse are in a protected class. But when we tease that part out, we actually strengthen the law because we no longer have to prove discriminatory intent. So we're actually providing more protections by passing this law for people in protected classes. And that's the piece that I argue when I talk about this, is that Black women especially will have stronger protections, and they'll have a tool to um, climb the ladder more easily, because right now they're being held down by workplace abuse, by aggression and dismissiveness from the people at the top, who are most commonly white men in power. So I want to just focus on that part. This actual section 1 goes over definitions, and I will just read them really quickly. First is an employee is any person who renders services to an employer, contractor, or any other entity and receives compensation for those services, including full and part-time paid employees, temporary employees, contracted employees, and independent contractors. An employer is a person or entity of any size who obtains services from a full or part-time paid employee, temporary employee, contracted employee, or independent contractor, and hires at least one employee for any compensation. And then a representative employee is an employee in a leadership, management, or legal position whose responsibility is to advise on, oversee, and or enforce organizational policies. Section 2 is our definition of workplace bullying. This is based on the EEOC definition, and I will just read through this. Workplace bullying shall be unlawful. Workplace bullying is unwelcome, degrading, and dehumanizing conduct that is severe or pervasive enough to create a work environment that a reasonable person would consider toxic, hostile, or abusive. Workplace bullying may be perpetrated by one or more persons. It does not include petty slights, annoyances, and isolated incidents unless serious. Factors to be considered in determining whether workplace bullying exists include, but are not limited to, the nature, frequency, and duration of the conduct and the context in which the conduct occurs. Workplace bullying is found by a review of the totality of the circumstances. So we really went through a lot of different ways of looking at this and came down to looking at what already exists and liked the EEOC definition. So that's the first piece, defining workplace bullying and declaring that it is unlawful. But the next piece is all about employers' requirements. So I'm going to go through these A through F. This says that employers and representative employees shall take all reasonable, preventative, and responsive measures to provide safe work environments free from bullying by A, acknowledging and responding to complaints of bullying within a reasonable time frame appropriate to the level of urgency. And this is to get at the fact that employers aren't acknowledging workplace bullying. They're not acknowledging our complaints of it. If they do acknowledge the complaints of it, they're not handled adequately. And we'll get into that in the next few steps here. But we want them to recognize that if somebody comes to them with a complaint, that they are to handle it within a reasonable time frame. The next one is The problem is that the employers are often dragging out sham investigations. So our next requirement is for employers to provide and execute a transparent, timely complaint process that includes a legitimate, fair, fact finding investigation and the issuance of timely and accurate reports of findings. The next one addresses the fact that employers aren't often disciplining the bully. So, this requires them to provide and execute a transparent disciplinary process according to the severity of the offense within a reasonable time frame, if applicable, including but not limited to coaching, counseling, a warning, or other disciplinary action, including removal of supervisory duties and or termination. The next issue is that employers aren't often maintaining accurate records. So we here D requires them to maintain accurate records of complaints, findings, and discipline. And then the last two are around the fact that workers should know their rights. So we have in this bill a requirement um, for writing, distributing, posting, and otherwise providing a written preventative policy against all forms of bullying to include an anti-retaliation policy and an identification and description of all reporting methods consistent with this section and all other laws within 90 days. Such policies shall be distributed to employees on a regular basis. And then it also requires training of employees on such preventative and reporting policies. Um, we also wanted to include the fact that employers have other tools to misuse their power around this issue specifically. So, Section C says it shall be unlawful for an employer or representative employee to mandate, offer, or use mediation and or arbitration of a bullying complaint prior to the employee's retaining of counsel. B, mandate, offer, or use a non-disclosure or non-disparagement agreement related to a bullying complaint, and or engage in an adverse employment action. An adverse employment action occurs when an employee opposes an unlawful employment practice and or exercises a right under this section and is then the target of forced resignation, termination, demotion, unfavorable reassignment, failure to promote, disciplinary action, reduction in compensation, constructive discharge, or a similar action. So we want to eliminate the ability of the employer to retaliate against somebody who's making a complaint, to require forced arbitration or mediation, and to use a non-disclosure or non-disparagement agreement to protect themselves. And these are tools that, forced arbitration clauses are often written in the fine print into a, an agreement that an employee signs upon starting a job. So they don't often know that they've signed on to this. And so we are trying to eliminate the ability for employers to police themselves, to cover up serial abuse, and then to retaliate against employees who make a complaint. We in this section, we also say a violation or violations of any part of this section can be enforced by a private right of action against an individual employee and or employer in violation of this act. So in other words, you can use this act to sue the employer and or the bully themselves. Section 3 is the damages section. So complainants who provide a violation of Section 2 or any of its subparts shall be entitled to all remedies necessary to make such complainants whole. Remedies shall include but not be limited to A, compensatory damages to include economic, back pay, and front pay and or related medical expenses, and non-economic, pain, suffering, and or distress. Punitive damages when a violation is extreme and or egregious. Injunctive relief whereby the court may enjoin the defendant from engaging in the unlawful employment practice and may order any other relief deemed appropriate, reinstatement of work and or removal of the bullying employee from the complainant's work environment, or removal of supervisory duties or termination of said employee, and restorative measures, correction of reputational damage, including false statements made, the disciplinary record and or performance evaluations of the complainant, and or public notification of the case without disclosing the plaintiff's name if desired by the plaintiff. In other words, where in this last point, where employers often try to cover up what they're doing, this gives the plaintiff the option to make it public. Says in instances where the employer violates section 2B, E, and or F, the penalty shall not exceed $100 for each offense. That's the part where we're talking about notifying employees of their rights. In all other instances, the complainant shall receive the greater of all damages as identified above, or $5,000 per violation of section 2A, 2B, and or 2C for a maximum of $15,000. That's really to say that if the all of the damages here in section 3A through D can amount to more than $15,000, and that is what the employee is due. But if they don't have any of these other damages, and they're suing specifically for a toxic work environment, that they won't get um, some sort of they won't get a specific amount for every single offense. They will get $5,000 for violating each of those sections. So it really is a way to quantify what somebody who simply is declaring a toxic work environment can get. This also says that the at-fault party shall pay the plaintiff's reasonable attorney's fees and costs. A prevailing employer shall not be awarded fees and costs. Other bills that address this issue have much shorter periods to file a legal claim. We have put this at 3 years, knowing that people need some time to heal. So this says any person who has a cause of action under the provisions of this act shall have a period of 3 years after the last violation of Section 2 of this act to file said cause of action. And then B says a pseudonym can be used in any and all instances at the plaintiff's request. We have heard from employees who've been abused at work that it's problematic for their future career to have their name in public records suing their employer and being deemed a troublemaker. So we're saying that they can use a pseudonym to protect their what should be a confidential situation if they choose to. One thing that we removed from this this version of the bill is to enlist the state in having an independent agency to address this issue that would run investigations and make judgments about the employer's behavior or negligence. I'm in Massachusetts, and in Massachusetts, we met with the agency that handles discrimination claims. It's called the Massachusetts Commission Against Discrimination. And in a lot of other states, this is called the Human Rights Commission. And so the scope of the human rights commissions are bigger than an agency focused on discrimination. And so in Massachusetts, if we were to get an outside agency to work on this, we would actually have to set up a new agency or get the essentially rename the Massachusetts Commission Against Discrimination so that their scope would be expanded. So if you are in a state that has, especially that has a human rights commission where you would simply be expanding their scope, you can ask for modifying their scope in the language of the bill. Or you could ask for creating a new agency. We're all for big asks, that knowing that this bill will be watered down, and that as long as the teeth of the bill are still there, that's what we care about. But ultimately, ideally, we would want there to be some sort of independent agency to investigate claims. And if it's a claim with a state agency, we're not sure how independent that would be, but it would otherwise be independent. And so that's what we encourage states to explore in adding something to their bills about the scope of their human rights commission to address this, and even meeting with their Human Rights Commission to see, if they would support this. Usually they're understaffed, and we have some information on um, what it might take in a state to what level of funding it might take to expand the scope, but we can talk about that with you depending on what you want to do. Other options we're learning, we can look more at existing legislation with guidance from legal experts to see if we can modify existing law. We can also divide up the bill to improve workplaces incrementally, which is more work, but may take longer, but will give us wins along the way, give stronger protections along the way, and give less for legislators to object to. So if a legislator finds, mostly supports the bill, but just finds one aspect they don't like, they could vote against the bill. So this strategy would take longer, or possibly, but it would give more protections incrementally. We are also looking at will employment. Banning at-will employment will give employees a baseline of rights. The idea is for U.S. employers to move to employment contracts, as many other countries do, which would allow employees to speak up more frequently without fear of retaliation. Right now, employees are at the will of their employers in every state but Montana. And we want to make illegal both wrongful termination and constructive discharge, which is pushing out an employee. We've heard pros and cons about banning at-will employment, but it seems like banning it has much more pros in terms of giving employees a baseline of rights. So it's something that we're looking into, drafting a model bill. Many states have already introduced at-will employment. You can see on our website, if you look at the issues section, what states those are, maybe even partnering with any groups that you Google who are backing that bill. But we would like to have a model bill to introduce in states where there's nothing introduced in terms of at-will employment. I want to go over why we're taking a state-by-state strategy instead of a federal one, although if we do get a federal supporter, we will gladly, we would love somebody to introduce this on the federal level simply for base building purposes. But the reason why we're taking this strategy is it's harder to reach national consensus than state consensus due to the size and diverse regional cultures of the US, the strength of the state governments, and laws that overlap with psychological harassment and abuse issues. I want to show you, you may have already seen this, but a video narrated by Jennifer Lawrence describing the history of this strategy, why it's worked, and why this group that she works with, called Represent Us, advocates for this. So I wanna play this for you quickly.
This line is from a Bloomberg News study. It finds that throughout American history, passing state laws leads to federal victory. Let me show you what I mean. This chart shows the number of states over time that pass laws giving women the right to vote. When it hits the right side of the chart, that's the federal victory. Okay, now I want you to watch the blue line. We're gonna do this again with interracial marriage. There were a few states in the Northeast that made it legal decades ago, and centuries go by, and we hit this blue line where all of a sudden there's a rush of activity, which leads pretty quickly to federal passage. So here we are again with same-sex marriage. One state, Massachusetts, for many years. A couple decades later, we hit that blue line, a jump in state activity and federal passage. This isn't about these issues. This is about a winning political strategy. The crucial finding in the Bloomberg study is that a key event, often a court decision or a grassroots campaign reaching maturity, triggers a rush of state activity that ultimately leads to a change in federal law.
So we have plans for teams and efforts on the ground in roughly 20 states. We're trying to find a state legislator or a lead sponsor to introduce the Workplace Psychological Safety Act in those states. and know that it only takes one legislator to get started. We don't, it doesn't, finding that one legislator can be a lot of work. Sometimes it's not, though. Sometimes it's really doing some research first before approaching a legislator who might be very likely to introduce this, because of their history with workers' rights legislation, their personal experience, or their likelihood to have personal experience with this issue. We can walk you through that piece of it, if we haven't already, but know that it only takes one legislator to get started. It generally takes several years, even decades, to pass legislation. Every session generally builds on the previous session, even though we get a new bill number each session. As an example, paid FMLA took 20 years to pass in Massachusetts. We're already a little more than 10 years in with introducing workplace anti-abuse legislation in the US, with other bills that we've worked on that have been introduced, that we saw flaws in. So the issue is out there. It's been out there. And we're hoping, if it follows the same path as paid FMLA in Massachusetts and other workers' rights bills that we've heard about, that we have less than a decade to see action on this, and then hopefully a domino effect. Once one state passes the bill, we know every time we testify, one of the major questions we get asked is what other states have passed this. And once we can answer that with a specific state, we think we will have a lot more traction. So if you have any questions, feel free to email me or info@endworkplaceabuse.com, which I also check. We are absolutely open to changes in the bill, any questions on decisions that we made. But we would love to have conversations with you about the why, if you have certain changes that you like made, and we can see if it makes sense to make them. So email at any time. And thank you so much.